What do you have? What's the first one you have for us?
Well, yeah, I mean, I know you want to talk about a bit about the injunctions on the year, and we can do that in a bit. But before we get to it, I guess just the last month, there were two important decisions on ineffective assistance of counsel, which all of your attorney listeners obviously care about. The first was out of the board in matter of Melgar, and just boiled down, the board wants us to start lazadaing ourselves, file bar complaints against ourselves if we are going to be filing a motion to reopen based on ineffective assistance of counsel. And the same attorney filing that motion is the prior attorney. Now, that is a weird thing anyway, to say that you were mistaken the first time, but then again, everybody makes mistakes.
Mm-hmm.
But even if you aren't the second attorney filing the motion to reopen based on ineffective assistance of counsel, in some circuits the former attorney can fall on their own sword, so to speak, and submit and say to the board or the immigration court, yeah, I messed up, no bar complaint, but yes, this was my mistake. In a matter of Melgar, the board would not have us do that. Now, don't get me wrong, as I said on the podcast, what constitutes ineffective assistance of counsel, as I read it, is a Sixth Amendment and maybe a due process issue. And so the circuit court has the last say on whether substantial compliance with matter of Lazada, including the filing of a bar complaint, is required. And I don't think matter of Melgar overturns anything in any circuit that says you don't have to file a bar complaint where the ineffective assistance counsel is plain on its face, such as with the Ninth Circuit. But I mean, there's some like there's quotes. Like, here's the quote from Melgar: there may be valid reasons for not submitting a bar complaint, such as the death of a prior attorney or his disbarment. But the respondent has not stated one here, except for a self-serving purpose, which we will not accept. I mean, it's all self-serving when there's a motion to reopen. That doesn't make it wrong if there is an effective assistance of counsel. So that's the board trying to tighten up um, motions to reopen based on ineffective assistance of counsel, which no doubt, I mean, from my time with the court, they are abused, but also they serve a very important purpose. And then on the heels of matter of Melgar, the 11th Circuit published a case called Dos Santos v. U.S. Attorney General. And that case might be even more scary. And in this case, the prior attorney in immigration court conceded that Ms. Dos Santos had entered without inspection and admission and was therefore removable when she had been inspected and admitted. So, like, there's really no doubt that the attorney messed up and they made a concession that they shouldn't have made. And before the board and the appeal and then the 11th Circuit, and obviously it gets complicated, but the 11th Circuit would not allow Ms. Dos Santos to get out of that mistaken concession by her attorney, even though it was completely wrong. And in order to get around an attorney's concession, the 11th Circuit would have them make a showing that factors in all these three circumstances of whether the concession was untrue or incorrect, which was the case with Ms. Dos Santos, whether the concession was so unfair that it led to an unjust result, seemed to be the case in Dos Santos, and whether the concession was the result of unreasonable professional judgment. But then going on to unreasonable professional judgment, the 11th Circuit would kind of link it up to ineffective assistance of counsel, which requires a prejudice showing as well. And so in this case, the 11th Circuit said even if the attorney mistakenly conceded it, it didn't actually prejudice Ms. Dos Santos because she wasn't eligible for relief and all this stuff. And the quote in the 11th is, the concession must be so unfair that it led to an unjust result or that it was the product of unreasonable professional judgment. So again, tightening the noose on um, when respondents, when non-citizens can change the results in their case based on their attorney's mistake, both from the board and the 11th Circuit. Kind of linked to ineffective assistance, kind of not. I don't know. They're kind of tough pills to swallow for me. If I was a non-citizen with an attorney, you try and hire the best attorney possible. But if that attorney makes a mistake, I think it's a legal fiction to believe that the non-citizen should be second guessing their attorney.
Yeah.
and be bound to everything they do and be questioning their judgment at every step of the way. That's why you hire an attorney, and it's gotten so complicated. But so that's a matter of Melgar and Dos Santos v. U.S. Attorney General from the last month.
Fun Merry Christmas.
Yeah, well, right. But yeah, I don't know.
In the Dos Santos case, she had entered with inspection and it was admitted. Would that have made a difference in the case? I read it. I kind of lost track of what was going on there.
Yeah. Well, so it wouldn't have at the time because they weren't married, because she wasn't married to a U.S. citizen, didn't have any grounds to adjust at the time. I believe she became adjustment eligible later, which is why the whole fight was there, to try and get it back before the immigration judge and to get rid of that concession.
So that's the thing. So when they said that injustice has to be really egregious, are they saying because at the time that the concession was made, it didn't make a difference? So, okay, not later on it became okay? Or
Yeah, they wouldn't look at it like that. At the time, it wasn't so egregious. At the time, it could have been a professional judgment, and they're conceding. The 11th Circuit is saying it could be a professional judgment because when you admit and concede, the IJ is happy, and they don't have to do. And so you might be trying to get into the immigration judge's good graces, which is of course not how the immigration judges ever look at it in court. They really get upset if you don't admit and concede. But the 11th Circuit is saying, oh, you can admit and concede as a tactical decision. So maybe remind the judges that you're making a tactical decision not to admit and concede. But yeah,
right.
the 11th Circuit, the board, they all want to go back in time at the point of the ineffective assistance, at the point of the concession.
I guess
So
that
that, yeah.
tactic strategy of always denying everything in an NTA would be the way to go.
Yeah, well, Dos Santos' decision is saying that is a tactical decision.
Yeah.
And you never know what's going to happen later. And, just one more point, because you said it was a bit of a negative, not trying to be negative, but so often in immigration. But as I said on the podcast, this attorney admission and concession thing, it applies equally to DHS. And I've used it against DHS. I've succeeded before, even before Dos Santos. DHS is in court representing their client, DHS, the trial attorney. An attorney's admissions and concessions that your client is not a flight risk, that your client is not a danger, that your client warrants adjustment as a matter of discretion. All of those things that are said in open court are admissions and concessions. And a case like Dos Santos binds DHS equally. And so we shouldn't all be just not saying anything, right? Because that's crazy. But, if we're bound, so is DHS.